photography coming over the other side. But welcome everybody to hopefully just a brief canter through the Attorney General's guidelines, which obviously is a hot topic for everybody at the moment and very, very exciting. What I've done so that everyone can know that they don't have to panic and watch or take notes or anything is there's a document. The document is sort of formatted as a set of slides. If I'd had the time or the wherewithal, I might have converted it all to PowerPoint, but unfortunately I don't. So the document is available as a handout if anybody wants it or might find it useful. I will use that as the base point for talking so that you can look at a prettier document rather than having to look at me as we go along. But it's all being recorded, so those who are going to watch after the event, welcome belatedly to Foundry Chamber's unique series of webinar, seminar thingies. Okay, so let's get cracking. So this is me. There we go. And I've only written that up so that you know who it is that's talking to you. I have some idea that I have some vague experience in what I'm talking about. And let's get on then to the guidelines themselves. So how did it all kick off? Because we haven't had new guidelines for some years now. November 18, the Attorney General published his review of the efficiency and effectiveness of disclosure in the criminal justice system. And that and a number of other reviews that were being conducted basically indicated that there were major problems, not necessarily with the structure of the Act and the relevant codes and the guidance and so on, but with the way in which that was actually being put into practical effect. And the basic conclusions were there was therefore no need to change the CPIA disclosure scheme, the test, the Act, the structure, and so on, but just significant problems in their implementation. And the conclusion was reached that a culture change was required that would put the emphasis on performing all disclosure obligations fully and as early as possible, and expressing the optimistic idea that better use of technology would ensure that we'd all get our disclosure responsibilities sorted out that much more quickly and accurately. There was a consultation period, and then on the 31st of December, they'd been published some months before, we moved to the actual document coming into effect, and that's the AG's guidelines in 2020. Now, the key drivers for the new document was, and these are only expressions of view, not intended to be critical, obviously, a perceived failure by the police to effectively carry out their disclosure obligations, a concern that the CPS and the police were under-resourced, the need probably to update the guidance in view of the fact that everybody's digital phones were now 5 times bigger than they had been before. But the other key drivers that it seems to me that have really brought to a head the need to address disclosure more carefully is COVID, for one, which has generated a huge backlog of cases. And the other key things that have been happening to some extent discreetly in the background, but are now real and live, is front loading, which we'll come on to a bit later, which I think is actually a huge change in the way things are going to unfold for the future. But also driving the undercurrent of change is the need to stop major disclosure failings such as the Allen case happening in the future. So you need to think though of the Attorney General's guidelines as being only one part of a complementary package of measures and rules that govern the disclosure process. And they weren't published alone, because at the same time as the AG's guidelines came into effect, so did a new CPIA code of practice that hasn't heralded quite the same publicity, perhaps, as the AG's guidelines has, but also, again, the DPP director's guidance on charging has been reissued. And all those 3 documents complement each other. There is obviously a hierarchy that you obviously need to think about as well, because the CPIA code has perhaps greater force. It comes directly out of the statute, section 23 of CPIA. The director's guidance has some statutory force, but the AG's guidelines perhaps don't quite have that same level of authority, but nevertheless, for practical purposes, it perhaps makes little difference. At the time they were issued, the DPP came up with this rhetoric to tell us what they were going to do and all about what the prosecution were doing right. but what they're also going to do better in the future. Delivering mass training is apparently what's been going on in the background. Judge for yourself whether that's had any active effect, but acknowledging obviously that we need to push for improvements. And of course, this has all since come recently very topical with the Robert Buckland going on air and telling everybody that he apologizes for the state of play so far as the progression of rape investigations are concerned. So that's the new scheme. Into force on the 31st of October. Watch out you don't inadvertently pick off the wrong copy, because it got revised shortly before it was issued. And it replaces the AG's guidelines 2013, which had supplementary guidelines, but they've now been mushed together. So they're all in one document. And the intro to the guidelines themselves says this: it outlines the high principles which should be followed when the disclosure regime is applied throughout England and Wales, not designed to be an unequivocal statement of the law at any one time, nor are they, and this is really the key driver, a substitute for a thorough understanding of the relevant legislation, codes of practice, case law, and procedure. Now, that may be the way they express themselves. The practical reality may very well be that if you're in front of a court, the court's going to pretty much treat them as law, because they are what tells the prosecutor, the document that tells the prosecutor in practical terms what to do. The key points, and I've tried to find as much commentary as I can on these in order to inform what I was saying. There isn't a lot of it out there at the moment, but these are really the headlines. First of all, it is much, much longer than the last document, the last guideline. 2013, we had 27 pages. It's now gone up substantially to 44. Some commentators sort of underplayed the extent of the changes that this may bring into effect. And true it is that there's perhaps less in the way of major structural change, but it's really just at every single level, layering repeatedly what the prosecutor's obligations are in conjunction with the investigator. So it does spend a lot of time and words repeatedly emphasizing what the prosecutor's obligations are. It's structured on the basis of a sort of a follow-through, a systematic, staged analysis of the different processes that follow in disclosure, rather than simply focusing on what each person must do. Some of the key major revisions, though, are these: digital communications and personal material. Those are all receiving very significant major attention. Presumptive disclosure is now a new byword for handing over most of what's on a basic case MG6C, although it's not expressed perhaps quite in those terms. And there are new sections on the changes brought about by front-loading, and also a very new concept, PCE, or pre-charge defense engagement. So these are the headlines. We'll try to deal with these. And you also get some glossy pictures like these. The irony isn't wasted on us, no doubt, that it appears that disclosure is going round in circles. But you can see here the primary stages of the process are identified, the different people and what they're doing. So there's a couple of pictures that bulk out the document to some degree. But let's move quickly on. They do, though, reveal this. I'm going backwards slightly. They do reveal this sort of problem, though. This is one of my key bugbears that I'm dealing with disclosure, is the irrelevant material, which still sits there and creates major risk. And I don't know why they just don't get rid of it and just tell everybody to keep everything and don't destroy a thing. And that is the concept of irrelevant material that's been seized. And the Act, and indeed the guideline, the AG's guideline, still retains the principle. It's not necessary, as you can see there under irrelevant material, to retain material which is incapable of impacting on the case. But at least the guideline now makes abundantly clear to the investigator that they dispense or dispose with material essentially at their peril, because it now says they should exercise considerable caution in reaching the conclusion that material is incapable of having any impact on the case, because what may look banal at the beginning can become very serious at the end. What may look like just an invoice or a piece of correspondence in the right circumstances becomes the critical material in the case. my view, for what it's worth, it might just have been easier to say everything you seize, don't destroy it, just keep it, and it'll all be available for everybody to see for here on after. Let's move swiftly on to the actual content of the guidelines themselves. Now, what I've done here is when you go through and analyze the actual text itself, is what I've tried to do to help everybody is to group together disparate parts of the guideline, which appear in sort of weird paragraphs all over the place. Certain lack of cohesion and logical sequencing appears to have come to bear. But within the little red boxes there, the square brackets, I'm giving you the paragraph references from the AG's guidelines. And what I try to do is to group together the key paragraphs under headings that seem to me to be actually a more helpful way of analysing the contents of the guidelines. So the first heading here, we see responsibilities of the prosecutor. And you'll see that as you just scroll your eye down the list of paragraph references there, that the guidance picks up throughout different pieces of guidance in all sorts of different parts of the document, which is slightly bizarre, but which nevertheless carry quite powerful messages about what's required. You'll see that also next to each of these little red square brackets, I put a little guide, a word to describe the feature that paragraph introduces. Occasionally, you'll see I've introduced concepts such as an A. The idea here is, so for example, here, if I can manage to highlight this successfully, there's a little A there, where where you get a big bulky paragraph. I've tried to sort of break it up into an A, B, C, D just to reflect the different sentences within, but that's the scheme I've adopted. And where I'm picking out from other material, you'll see that drops in blue, just to give you a little bit of a difference. So you do get some sort of powerful messages that have been introduced into the guidelines. So disclosure now is an integral part of an investigation, not something that should be considered in isolation. And the new scheme is it's got to be thought of from the beginning. It is as much an important part of the whole process of getting a case to court as the gathering of the evidence. It is just the flip side of that. That strategy and that approach has got to influence the investigator from the get-go. The modern document that does this is the IMD, the Investigation Management Document, which we're beginning to see more and more of, particularly outside London, funnily enough. And that requires the investigator from the very outset to get to grips with disclosure. 100A is an important paragraph. In all cases, it's essential the prosecution takes a grip on the case and its disclosure requirements at an early stage, gives it sufficient priority, works together with the prosecutor and the disclosure officer and the investigator, so that all are pointing in the right direction to ensure that the Crown's overall disclosure obligations are met. And there's a heavy emphasis as you go through the guidance on repeatedly checks and balances, a division of responsibility. So where it is that the investigator has the statutory or the code responsibility for doing things, so the AG's guidelines impose a parallel obligation on the prosecutor to supervise that effectively. They're not taking over the responsibility because it's not their obligation, but they're obliged to check what's going on all the time. And that proliferates all the way through the guideline. And that's what I've described here, this sort of layering of responsibility that influences the whole of the guideline. There's also some useful tidbits for the defence to focus on, and also for you to, as prosecutors or as prosecution advocates, to introduce into the conference situation if you're being troubled by a failure to be transparent with you by a case officer, because as 24 says, paragraph 24, nothing is off limits. There is no aspect of an investigation about which prosecutors are unable to ask probing questions. But the corollary of that, of course, is that there's a consequent expectation that the prosecutor will be asking those probing questions in order to get the disclosure obligations sorted out. And so the supervisory obligation, 22, prosecutors are expected to effectively tell the investigator or the disclosure officer when they're not doing what they should do, policing, if you like, their responsibilities and making sure they're done correctly, and effectively requiring them to proactively go out and provide advice to make sure that everything is being done correctly, including things like pursuing reasonable lines of inquiry where those arise, for which we'll use the acronym RLEs, as we'll see as we carry on. So what about the disclosure practicalities? Some nice bits here for prosecuting advocates. So obviously it's not your responsibility to be keeping the log, but everything is supposed to be being logged. Years ago, Customs had a concept known as a disclosure record. I think the CPS are now more universally relying on those as well. Everything is supposed to be logged. And this is to deal with the sort of situation that arose in Allen. So if you read the CPS Inspectorate report on Allen and what went wrong, one of the key concerns they had was that a second prosecutor who came in, the case lawyer came in, didn't understand, wasn't able to pick up on the decisions or indecisions or failures to decide that had been occurred before they came into the case. But from a prosecuting advocate's perspective, conferences are now emphasised, regular case conferences to ensure that prosecutors are apprised of all the relevant developments, which have to be fully recorded, minuted. All correspondence has to be retained in relation to disclosure, or a record kept of absolutely everything that is disclosed, including, obviously, as prosecuting advocates, when you're at court, it must be absolutely clear after the event, on appeal or retrial or whatever takes place subsequently, exactly what has been handed over. And as I said at the comment at the bottom there, all of this designed to fix the sort of problems that occurred in Allen. Schedules, we'll take this pretty swiftly. Obviously, it needs to be borne in mind how important a schedule is to the prosecutor. The CPS prosecutor will be looking at the schedule, and primarily their decision-making will be premised on what's written on that schedule. So the guidance builds on that and makes sure that everything has to be accurately and fully described. A new concept seems to be introduced by this 2020 guidance of the thinking approach, and partly born of case law that is now referenced in the guidelines itself. But the schedule itself must demonstrate, you see there at 59, a transparent and thinking approach to the disclosure exercise. And we all know what a good schedule looks like, because not only does it just set out a headline as to what the material is, but it then describes it fully. It articulates an analysis, perhaps, of the potential significance of the document, and then articulates, even shortly, why the decision has been made that that information or that document is not one to which disclosure should follow, or is not one that needs to be revealed to the prosecutor. But all that spelt out early for the benefit of the prosecutor, for the benefit of the CPS reviewing lawyer, makes their task that much easier and increases the prospect that accurate decisions will be made. There's also, in the checks and balances field there, at the bottom there, you can see 83 and 62, the prosecutor's review of that schedule must be done early. It's slightly disappointing that the guideline felt it necessary to spell out the fact that the prosecutor must be alert to the possibility that no schedules have been provided. But clearly that was felt one of the basic building blocks that needed to be emphasized. But you can see there that the thematic continuation of the same theme of supervision, that the prosecutor owes a responsibility to check what's been done, make sure it's done correctly. As you see at the bottom there at 62, where relevant unused has been omitted, the material isn't correctly described, then there's an obligation to task the disclosure officer to rectify it, and importantly, a guideline obligation for the disclosure officer to comply tenuously with that requirement. One of the key building blocks of the new AG's guidelines is its focus on reasonable lines of inquiry, which of course spills very heavily into private and personal information and digital material, particularly mobile phones. So here you see in blue, I've just outlined for reference purposes what the actual CPI code obligation says. The guideline builds on that. 17C, a fair investigation does not mean an endless investigation, obviously, unless you're on an hourly rate. But it's a matter ultimately for the investigator, according to the code, with the assistance of the prosecutor, decide what constitutes a reasonable line of inquiry. But active advice is required. The prosecutor can't just sit back. They're required to engage with the investigator and provide them with the advice that they require as to what other potential further reasonable lines of inquiry are necessary. And that may require consultation with the defense. But the investigator and disclosure officers have to give thought to defining and articulating the scope of their investigation, thinking not just what they want to go after, but how it can best be obtained. And ultimately, this key component of emphasis, that the reasonableness of particular lines of inquiry has to be assessed on a case-by-case basis, having regard to the prospect of getting the relevant material, the perceived relevance of that material, and the effect it's going to have on the people that you're asking to get the material from. So it's no longer one size fits all, and this is a key feature of the new guidelines, because there has been a tendency to just do the one-stop shop on a lot of cases. This is a sex case, it's RASO, I must have the medical, the social services, I must have the schools material, I must have the phone. And it's just a simple tick box. These things are automatically required. That, I'm afraid, is now gone. And it's certainly gone with the new guidelines that have been issued on that subject. And instead, in their place, a thinking approach, a case-by-case analysis of reasonableness of those lines of inquiry is required. They may still be reasonable, but it has to be justified on a case-by-case basis. And that feeds into this side of things, which is completely new for the 2020 guidelines, because they've embraced the concept of ECHR rights, both on the one hand, balancing the right to a fair trial under Article 6, and on the other hand, the right to private and family life, which of course doesn't just apply to the complainant, it applies equally to other witnesses, but also, as the guideline slightly out of left field perhaps, but reminds you that it also applies to the defendant as well. So here, investigators and prosecutors have got to be aware of the difficult questions that the tension between these two sets of rights gives rise. Obviously, and the guideline emphasizes this, ultimately, the right to a fair trial is absolute, whereas the right to private and family life is a measured right. It's not one it's one to which there can be an intrusion, and that intrusion follows the classic ECHR trilogy of examining whether or not it's in accordance with the law, whether it's necessary in the circumstances of that particular case, and also that it's proportionate. So these are the principles that the investigator and the prosecutor have got to follow in seeking to satisfy their disclosure obligations. And importantly, the guideline emphasizes that where you are talking about potentially disclosing personal private material to the defense, of course, for that to be in accordance with the law and necessary, disclosure can only be made in circumstances where it meets the CPIA disclosure test. So no pragmatic disclosure is permissible. Strict compliance to give effect, proper effect, to the Article 8 rights of that particular individual. And so, and also emphasizing that, of course, redactions should be used to ensure that only the relevant is disclosed, and where the irrelevant or not satisfying the CPI test is indicated in the material, that material should be redacted out. That's expressly provided. Another feature of the new guidance is its footnotes. There's quite a few footnotes, and you'll see N6 as referenced there, and that the guideline repeatedly reminds people of where case law can be found that deals with these issues. So Beta James, the case that everybody's familiar with now, dealing with mobile phone evidence, is expressly drawn to the attention of those who prosecute through the AG's guidelines. So personal and private material, of course, it isn't exclusively mobile phones, although that is the kind of the hot topic for the moment. So get yourself into grips with these phrases. I know that in the year 2000, we had the Human Rights Act, or around that time it came into force, and we all got trained on that, and we got familiar with the accordance with laws, necessity and proportionality trilogy. That they're back again, that raise their head again, and they impact upon the decisions that you're going to be making here. So the sort of practical questions that you as a prosecutor or even as a defense advocate in trying to articulate your arguments need to be considering. Incremental approach to the degree of intrusion. If there is a lesser way of getting at the material, find that, think of that. So what review is required, the questions that you should be asking, how review should be conducted, the methodology, the mechanics of it. What is the least intrusive method, because otherwise it's not going to be proportionate to the disclosure need that is identified. Are particular parameters for searching best suited? So if you need particular types of material, just look for that material, apply criteria that will ensure you get what you need and you don't intrude on the personal and private material that doesn't touch upon that particular issue. Do you need all of it, or can you just need a particular part of it? If it's SMS material that's required, just get the SMS. You don't need to have the whole lot. Alternatively, can you get it from another source? So the case law, I think, is slightly unfair on the defendant here. It says, oh, well, if you can get it from the defendant, you don't need to bothering the complainant for her mobile phone. It doesn't seem to quite square with the balance of articulate rights between complainant and defendant, but that's what the Court of Appeal have said. And also the simple mechanics of it, V3 as I've referenced there, don't take the phone, just get the phone brought in, plug it into the machine, connect the material, recover the material you need, hand the phone back, rather than seizing if that's a less intrusive method, can get what it is that you need. And all these justifications for pursuing whatever disclosure strategy is going to be adopted have got to be transparent, because you're going to be sharing them directly with the defense via the medium of the DMD. So the investigator's got to articulate it, and has got to justify what are the reasonable lines of inquiry, because the other person you've got to potentially speak to is the complainant or the witness, and explain that to them also as the code stipulates. So there's your rationale. The justification for pursuing your reasonable lines of inquiry will include, first of all, consultation with the prosecutor, if you're an investigator, who's going to have to themselves consider the scope of those RLEs, those reasonable lines of inquiry, for the drafting of their DMD, which they're going to be writing up. You've got to engage with the defense. They may have counter-arguments, submissions, representations to make to you about the way in which you're going to approach your responsibilities. You may have to provide information to the witness about how the material is going to be handled to justify the intrusion that you're going to be undertaking. And if the witness or the complainant then refuses to cooperate in that process, you need to consider that. Interestingly here, at 13 of the guideline, it doesn't actually come up with any answers about what you're supposed to do in these circumstances, apart from consider the information you're giving the witness and their reasons for the refusal, and how the trial process can address the absence of such material. What it doesn't talk about is what exactly you're supposed to do, other than throw in the towel if you have to. It doesn't consider, for example, or talk about the slightly thorny issue of pursuing coercive powers to get hold of a phone or other personal material that you might require. There is an interesting example that's given in the AG's guidelines. I think, again, this is a new way of addressing the requirements. So it specifically goes to an issue of the complainant mobile phone in a sexual case, and asks the questions and talks through whether or not there would be a reasonable line of inquiry in taking the phone. So in a historical case where phone material is not likely to be of any relevance whatsoever, there clearly is no necessity to take the phone unless, for example, there's more recent complaint and that the prosecutor wants to evidence. Those are the sort of issues that are in play. Don't forget the guideline also focuses very heavily on digital material. Digital material obviously isn't just mobile phones, but frankly, mobile phones are the most frequent occurrence of them. Every aspect of this is then played out again in the digital material sections. So at 56, prosecutors and investigators must ensure any line of inquiry pursued of a victim or witness is reasonable in the context of the likely issues. A fact-specific decision is required, and then making it clear that digital devices should not be obtained as a matter of course. So the digital stripping of the complainant in the classic rape case should be a thing of the past. We now move to a case-by-case careful analysis of the value of the material and the level of intrusion that is going to involve. Quite a useful point made in the guideline is if you get a digital device and it becomes apparent that it is not likely to contain any material, don't cling on to it, hand it back. And the return is covered. There's a particular emphasis in the Annex A of the guideline. You'll see there I've marked some of these square brackets with an A as a precursor. That's reference to the Annex A, is on obtaining many more devices by cooperation. It's not entirely clear what this means. I mean, you can ask a defendant if he wants to hand over his phone. No doubt he'll probably say, no, thank you. A complainant asked without any explanation to just hand over their phone is obviously probably like to say the same thing. That's the emphasis that the guideline places. And all of this guideline, obviously, it reinforces what is now current guidance already, but the guideline spells out as being a guideline to which prosecutors must have reference in the two documents that I've identified there that specifically focus on these issues. The CPS Guide to Reasonable Lines of Inquiry and Communications Evidence, and also their guidelines on communication evidence. For all those documents that I've been referring to, you'll see there are footnotes giving you the online references to pick off those documents as you see fit. So I've talked a little bit about the issues that crop up here. I mean, the practical reality is, let's face it, that phones are a complete nightmare. They contain vast quantities of so many different types of data, categories of data that are only increasing as technology moves on. I mean, we've gone from the sort of more basic situation of comms material, communications, text, contacts, phone registers and so on, to phones that provide location, constant location update information, images, but now obviously other crazy stuff like health data on a phone, with everybody's smartphone connected to their smart watch device, their Apple Watch and so on. You can check out somebody's heart rate at the time that a particular event was taking place if you are so minded and you have the technology to do so, where they were connected to Wi-Fi. I think some of the observations that you see in some of the case law, to some extent also naive to the many different ways in which communications evidence can be relevant, and also the many different ways in which people choose to record. So one of the issues that I've had in cases in which I've been involved is people taking screenshots of their communications and then deleting the communication itself. And then that particular screenshot sitting in a folder containing another 100,000 images. How the hell are you going to find that? But once you do realize that there is one of those, what do you do about it? And the short answer is that you're left with little choice at that point, but then to take the phone into your possession, into the prosecutor's possession, through the investigator, and go through all of the images to find all those screenshots. It is frankly a nightmare. But I also think that the emphasis is always, the emphasis you hear in the press and the emphasis that you hear from the case law is all about protecting the victim from digital stripping. But certainly my experience prosecuting Grasso work is that ignores the fact that most of the time it is the investigator who wants the phone from the complainant because it's likely to yield evidence that's going to support the case. And as a prosecutor, I'd much rather be in possession of all the material, if it's appropriate, of course, for it to be captured, so that you know exactly what the position is. You can accommodate any issues. And you also have to bear in mind that, of course, if it's communication between complainant and defendant, it means that the defendant will have that communication material in their possession already if you haven't got their phone, or they could have their WhatsApp online from a backup, or they could have their Facebook material available to them. So you just end that you risk ending up in a situation where you are unsighted on a whole raft of material which is potentially lethal to your complainant, and or will take your complainant by surprise. When it's possible, there are perfectly good explanations, but the complainant in the witness box faced with this material is struggling to deal with them. A lot of the talk also, I think, is also slightly naive to the timing issues that arise in an investigation. A complainant walks through the door of a police station. They've got a phone. The phone contains material of potential relevance. Do you hold fire on taking the phone as the investigator, or do you capture the material then, because you may not get an opportunity later, because later the material may no longer be on that phone? You may only get one chance, one opportunity of cooperation. So what do you do? It also assumes, a lot of the talk assumes that the tension is only between complainant and defendant in terms of intrusion, but quite often you get three-way tensions emerging, multi-suspect cases where you've got one phone or an ex-suspect. In a case I've got at the moment, I've got that issue. A seizure has taken place of a phone that belongs to an ex-suspect, which was found in the possession of the current defendant. You want to get it interrogated. You're struggling because the justification is said not to be there. The other thing that the AG's guidelines just completely perhaps fails to address is that the investigator and the disclosure officer are not actually the gatekeepers for access to the material. So the prosecutor and the investigator may together agree that a particular line of inquiry is appropriate, but that line of inquiry is stymied because the gatekeeper, the person with responsibility in the police for actually making the decision as to whether a particular phone is actually going to be downloaded, because it's in their view that matters, and they refuse. How on earth do you get around that situation? You can't go to the court and say, can I please have an order for it? Because it is said that the judge will look at you rather weirdly and say, but you've already got the phone, what's the problem? Yet, on a practical level, it's one thing that's very difficult to solve. Constructive suggestions. So, actions for going forward. Well, what do you do? Well, first of all, you have to justify. Reasonable lines of inquiry have all got to be pursued carefully and only where reasonable. But frequently, obtaining the phone, obtaining the relevant digital material may be perfectly reasonable. Don't adopt a knee-jerk approach. I think it's obviously fairly clear now that you don't drop a case simply because the complainant won't cooperate. There are a number of stages that will follow if the complainant doesn't wish to hand over. And the authorities, I think the case is E, which you'll see cited later on, has endorsed the continuation of a prosecution where the complainant has declined to hand over material and there's been no coercive power brought to bear. But also technology. I think this is where the system really needs proper investment, because so many officers just simply aren't trained to deal with the technology that they're facing, and the latest up-to-date technology makes things even more difficult. And they have outmoded tech with which to download phones. There aren't enough of the officers trained. There's a backlog of getting phones examined. All these issues really need to be got to grips with by the government if they're to make good on their promise that all of these cases will come through the system properly investigated in the way that they should. I'm going to skip through here because there's part of the purpose of having a document which you can all have, thank you, you're welcome, afterwards, is that you don't have to go through all the stuff. So it's a fairly exhaustive analysis of the guideline, but some of it either hasn't changed dramatically or is a very dense subject which is not really suitable for a quick discussion online. So here I've dealt with large volume digital material, which is covered heavily in Annex A of the guideline. Basically, you need to read it. It's substantial, it's lengthy, it's not terribly complicated, but it really does get to grips, descends right down into the detail of what is required. Key messages here: have the investigator, prosecutor and disclosure officer sit down and thrash out early doors exactly what's going to happen, preferably, get this, preferably before they walk through the door of the premises they're going to seize these devices from in terms of computers and so on. There is no expectation that everything is going to be gone through bite by bite. Engage with the defence, engage with the court, set out your stall, engage in phase disclosure where it's all too big to be dealt with in one go. Make sure you allow yourself the time and that everybody at every stage is kept in the loop. So there we go, lots of stuff about large volume disclosure exercises. Third-party material can be very tricky. It obviously engages, again, the personal and private material of people. The police, in my view, are getting fairly good at this now, and also after some years of difficulty getting hold of social services material, the third-party protocol, the joint protocol, which you can point to and wave around whenever you engage with a local authority, actually serves its purpose fairly well, so that what may be difficult to achieve on a coercive level in strict legal terms is usually capable of being practically solved by proper engagement. But because there hasn't been a dramatic change in the structure of things according to the guidelines, I'm going to leave you to review that for yourselves. Be aware of the guidelines and best practice, which I've referenced there. So there's the joint protocol, but also interestingly at this stage, it's interesting the way in which there's quite a bit of cross-fertilization in this set of guidelines, pointing to other documents and telling you where you need to go to look at and get your rules about how you do things. So interestingly here, the AG's guidelines refers directly back to the CPS Disclosure Manual and tells the prosecutor to go look at Chapter 5 to find out the answers to those sort of questions. So let's move on to some of the more new stuff that really is a genuine change since 2013 guidelines. PCE, pre-charge engagement. This is all completely new. It may have been referenced before in passing, but now it achieves a status of its own. It's got an acronym, and it is occupying the whole of Annex B. And essentially it means this, and you can see there at 25 from the main body of the guideline. In some investigations, it may be appropriate for the officer to seek engagement with the defence at the pre-charge stage. And this is likely to be where it's possible that PCE, pre-charge engagement, will lead to the defence volunteering additional information which may assist in identifying new lines of inquiry. So Annex B then tells you what to do. So what are the key takeaways from this? First of all, it's totally voluntary. It can be terminated at any time. It sits completely outside, although it sits in parallel with it, sits completely outside and isn't intended to impinge upon PACE interview. And equally, adverse inferences flowing from PACE interview. There's no question, therefore, of any adverse inferences flowing from a failure or refusal to engage in PCE. It shouldn't be used, that tension that exists there, it shouldn't be therefore used in relation to matters where the police are likely to seek to rely on the interviews or topics that are being relied on from the interviews, or silence in relation to those topics being relied for in interview. The Annex B gives you some guidelines, some examples. So potential further reasonable lines of inquiry. A defence advocate or a defence representative may point the police to say, you need to go and speak to this witness, we need to go and obtain this material, this CCTV we know is in existence for that particular inquiry. It's also obviously highly relevant to the context of digital material. We recommend that you go and get this person's phone because we know that there was this level of engagement, this channel of communication, which is relevant to the issues that you're looking at. We suggest you go and look at these medical records. Somewhat optimistically, the guidance, the AG's guidelines looks at talks about agreeing expert evidence, which seems, from my naive perspective, somewhat premature, but it is mentioned as well. The annex means that, or the rules in the annex mean that this PCE comes with a lot of baggage though as well. So everything has to be recorded. The guideline, the annex spells out all of the recording that's supposed to, or documentation that's supposed to be generated when this process unfolds. And interestingly, also provides for this topic as well, PCE disclosure. So pre-charge engagement disclosure, it emphasizing that you may need to go a little bit beyond the pre-interview disclosure in order to give the defendant, the suspect, a fair crack at the whip in terms of understanding what you're doing, making sure they're not misled, so that they can actively engage if they wish to in this pre-charge engagement phase. Because if they don't understand what's taking place, of course, the PCE, the prospect of pre-charge engagement becomes somewhat illusory as a right or an obligation, as you look at it, as the case may be. So it's all spelled out in Annex B. Take a look. Just some comments on that. So active defence. So if you have you've got a good case, whether or not you've answered questions in interview, if you know your defendant, your suspect has got a good case, and that there are things that you can point the investigator to, there's now a formal process for putting that in motion. If you know the CCTV is going to bear out what your client is saying, there is the possibility of being able to knock a police investigation effectively out of the water by some careful, measured and poignant pre-charge investigation. So, for example, CCTV, if you know there is particular CCTV in existence for a premises, which may be important because if the police haven't locked onto it, there's the prospect, of course, with CCTV being destroyed and overwritten before you've had a chance to do that. Digital material, obviously, again, there's the potential for very significant lines of inquiry if you're representing a corporate entity who obviously know their way around the corporate computer system an awful lot better than the investigators may do. Then, even if you don't wish to answer questions in interview and expose yourself to further questioning in that context, you may wish to make some measured, focused disclosures, if you like, pre-charge engagement disclosures about where people need to look to get the relevant records, which also may improve your situation as well if you're concerned that your company computer systems have been seized by the police and you want to get them back as soon as possible. Funding is an issue though, because of course, as with all these things, if you're going to pre-charge engage, advise your client about it, that the money needs to be there to provide for that. I don't have any direct knowledge of the position. I've read that there's no practical provision for such funding or no practical provision for it, although there are some theoretical ways in which it may be possible to get publicly funded assistance on these subjects. So it may become, as so often these things are, a niche option only available for those who can afford to pay for it. And there is also a concern perhaps that although the procedure is supposed to be voluntary, there's a risk that it may shift the emphasis away from the investigator fully carrying out the reasonable lines of inquiry that they should be finding out about, in deference to just doing what they've been asked to do by the defence, because that's the easy way out of the situation. So that's a PCE's one to take a look at, and we'll have to see how that plays out in due course. Front loading. Now this I think is a very important thing. It's certainly been coming down the track so far as major fraud investigations are concerned, but it is now complete across the board. Front loading meaning that all the reasonable lines of inquiry and all proper disclosure has been obtained before you even get to the stage of the charging decision. So reasonable lines of inquiry at 75 in the guideline, prosecutors must ensure that all reasonable lines of inquiry likely to affect the application of the full code test, so the decision in relation to charge, have been pursued before the test is applied, unless, and it's only a narrow gateway to escape, unless the prosecutor is satisfied that any further evidence or material is unlikely to affect the application of the full code test. That's the primary route by which front-loading is now the standard. It is the default. Deferral of a charging decision. So if you don't pursue reasonable lines of inquiry as an investigator, the CPS are expected to knock you back and tell you, no, go away, go and explore these RLEs, these reasonable lines of inquiry, because we are not going to make a charging decision until you've sorted that out. The other parts that I've identified there, paragraph 71 and 76, are to do with the other ways in which a charging decision might come about. So a threshold test. So when the police come to the prosecutor to have a custody type case resolved, which requires an immediate decision, a threshold test will be applied, and so this still needs to be considered in that context. Equally, where there's a police charging decision, they too will now have obligations in relation to front loading. But all of this is required to be spelt out by the investigator in the IMD, so that the prosecutor can then complete the DMD at an early stage in order to show that all those reasonable lines of inquiry have actually been pursued. So this is, for my part, I think this is actually a major step forward, and it is probably, because it's been coming for a while now, it is probably part of the cause for the huge backlog that is in play at the moment, because it is having the effect in realistic terms that cases are being delayed substantially by 2-3 years at a time, whilst all of those reasonable lines of inquiry are resolved. I'm not saying that's a bad thing, it's almost certainly a good thing, because prosecutors shouldn't be making a decision on incomplete material. And there's no going back to the bad old days when a case would be charged simply on the basis of the complainant's account. And in a RASO case, for example, as time unfolds and you head towards the trial, the third-party material, the other material starts to come through, and gradually you realize that the case just doesn't have the evidential legs that you thought it did at the outset. Because structurally, that's not a happy place for things to be. But it does have a significant impact. I don't think that government really recognize in their attempts to explain why there's delay and why cases are not getting through at the moment. I would say the simple answer is a major bottleneck caused by the front loading of all these charging decisions. But there you go, that's one for the politicians to resolve. Initial duty of disclosure, of course, it hasn't changed. It's still the same. It's important to bear that in mind. And the code tries to emphasize this, but we'll come on in a moment to the exception to this rule. Note this corker, 104, timing of initial disclosure. Best practice, where there's going to be a not guilty plea, is that service of initial disclosure should take place prior to the PTBH. I could probably count on the fingers of one hand the number of times that I've ever seen that happen. A reminder in the high-level parts of the guideline that the strict CPIA test still applies. Statutory disclosure does not require the disclosure of neutral material or material that is adverse to the defendant. But equally high-level principle, disclosure has got to be completed in a thinking manner in the light of the issues. And quoting parts of key authority, in this case, Ollie Wilson and Brooks, and picking out little tidbits from within the judgment about the way in which disclosure should be thought about. The key message from this part of it, as far as I'm concerned, which I think is where investigators sometimes, or disclosure officers sometimes fall down, is to fail to apply the thinking test to a situation. So, what if something appears on the face of it to be material that undermines or is capable of assisting? There's no two ways about it. It's got to be handed over. But yet sometimes an argument is advanced to try to explain away its assisting value. I struggle myself to find any justification for why the previous convictions of a witness who's giving evidence to the Crown aren't pretty much, as of right, handed over. Because is it not the case that a PNC that contains a previous conviction to some extent at least, is capable of undermining that individual who is a witness being called for the Crown. But yet, things are never as clear-cut when you attempt to resolve those sort of disclosure issues with your team. A useful one that's worth bearing in mind here, if you're a prosecution advocate, revelation of borderline material, 64, disclosure officer has an actual direct obligation to draw material to the attention of the prosecutor where they've got a doubt. In other words, they're not clear, sitting on the fence about it, it's borderline. They should in those circumstances, they're told in those circumstances to hand it over to the prosecutor, and that person will then be able to make the decision or advise them on the right way forward. But that brings us to this. So it's all on a case-by-case basis. You don't hand anything over that's neutral. You don't hand anything over that's adverse. Oh, wait a minute. Yes, you do. So we've now got presumptive categories of disclosure. Which is an interesting concept. I have to say, I don't really understand it because it's just illogical when you, Captain, when you look back to the CPIA test. You can't, on the one hand, say we're doing everything strictly by the book, strictly CPIA, and then on the other hand say, but presume to hand over all this stuff. Oh, but don't presume to hand it over because actually you're applying the CPIA test. It doesn't really stack up. It's frankly, in my view, my personal view, a complete fudge. But that's what it says. And let's face it, if that's what it says, pretty much this is what's going to happen. What it does, the code starts in the CPIA code itself. It says that there are categories of material which are likely to include information which meets the test for prosecution disclosure. And this material must be scheduled and provided to the prosecutor. So the starting point is that the investigator themselves, the disclosure officer, they're obliged to copy, to reveal to the prosecutor the actual presumptive disclosure material. And so, and the code then says that the investigator and the prosecutor are to start with the presumption that that material is likely to meet the disclosure test. Although it then goes on to say the material will need to be carefully considered and the disclosure test applied before a decision is made. Go fathom, really. So I think it's difficult to understand what they really want you to do. And they then go on to say, for example, at 91 in the guideline, this list of material is not intended to cause automatic disclosure. We'll see how that plays out in practice. What are the things that are presumptively disclosable? Well, they are these, and I've listed them there carefully. So standard stuff. These things did appear previously in other iterations of the AG's guidelines, going way back. But they were things that you were just being pointed to. You weren't being told that they were presumptively disclosable. So telephone records, crime reports, police notebooks, CCTV, including body-worn, presumably, custody records, interview records, any material casting doubt on witnesses, and so on. This is all fairly standard and familiar stuff. So what are the comments here? Well, far be from me to question it, what this actually logically means. But let's just think about the practicalities of it. Here are your choices for your prosecutor faced with a mountain of files in front of them. They need to be resolved. They've got documents falling into these categories, effectively leading them with two choices. Cursory review on the basis of the presumption, because you're going to likely hand them over anyway. Alternatively, full review, actually ploughing through the material page by page in order to find a way in which to rebut that presumption. In other words, because the practical reality is if you're not going to hand it over, you've got to be absolutely clear by some sort of complete reassurance exercise that it contains nothing that meets the test. So faced with those two options, one has to be realistic. The likely route that people are going to be going down is to disclose on the basis of the presumption. Now, that may sound a little bit cynical, but in fact, it may be, who knows, it may be that that's actually what the AG's guidelines is intended to achieve. But of course, it can't say that. It has to say that it's all subject to proper review, and it has to say that we're still applying strictly the CPIA test because the AG's guidelines can't change the test. Of course, it doesn't sit very well when you get into a situation of presumptive material that contains reference to personal or private material of complainants, because of course then other parts of the AG's guidelines tell you you're supposed to be applying strict CPIA. So what do you do there? Obviously attention then arises. But is this a bad thing? Well, probably not at the end of the day. In the short term, probably it will result in more disclosure in the majority of cases. Query whether or not, though, it's going to result in the absence of proper review of automatic disclosure, presumptive disclosure, so that material is being handed over but not receiving the full consideration that it otherwise ought to have done. I'm going to wrap up the rest fairly quickly. So DMDs, they are now here to stay, and they are live for all cases in the Crown Court now. They're only voluntary in Magistrates Court cases. You know how they work. The investigator tells the prosecutor what is going on, what they're investigating, and the prosecutor is then required to generate the document. It should be done by PTPH. Now, this is interesting. 111, case management. So the focus, or a focus of the PTPH must be, says the AG's guidelines, on the disclosure strategy. This will involve the defence identifying the likely trial issues, discussion of additional lines of inquiry, and scrutiny of the DMD. Now, I have been on cases where the DMD has been open during the course of a PTPH, but I don't remember that many of them where that sort of level of inquiry is being exercised. But it does create an opportunity for the defence, because proactive defence advocates and representatives will be able to take the prosecutor to task, and potentially at the PTPH when they're perhaps not ready to deal with those sort of focused inquiries. And why not? If you're ready to go as a defence advocate to make trouble, to get beneficial orders made in your favour by the court, why not have a go at that point in time? There's some of my comments there. So at PTPH, the court's supposed to be reviewing the DMD. In my experience, it very rarely happens. And in fairness to the defence as well, even, in some cases, privately funded defendant, or a case where the proceedings have been long running before they get to PTPH, and there is the potential for the defence to be ready to make those sort of representations. But in many other cases, they're simply not. And it's really somewhat pie in the sky to suggest that the defence can sensibly be expected in a run-of-the-mill type case, or worse still in a custody case where they may have barely seen their client by this point in time, to suggest that they're supposed to engage in a detailed discussion of the whys and wherefores of the DMD. And frankly, I don't think there's any judicial enthusiasm for it in any event. Defence statements, nothing new. It's just, obviously, this is talking about defence statements from a prosecutor's perspective. So there's lots of talk about how they've got to be full, and how if they don't give a full one, it's inadequate. You should be, as a prosecutor, taking it back to court, which is fair enough. And don't answer disclosure requests unless they go directly to issues that are raised in the defence statement. So you can look at those views. And the guidance obviously then continues and covers all the other stages of the trial, stage 3, 4, and so on. But you'll appreciate that I've given these less attention, because of course the net result of front loading everything is that by the stage of stage 3, you should have got this all sorted before. So if you're still floundering around at stage 3 with your disclosure, then something has gone badly wrong according to the scheme of the AG's guidelines. But obviously, continuing review. But also, this does also place a somewhat heavy onus on the trial advocate, ultimately, 134, making clear that the prosecution advocate ultimately in every case has a responsibility for satisfactory discharging the duty of continuing review on the basis of the material already supplied, and must actively decide whether or not they should be asking for more detail or more documents to enable them to carry out their responsibility. Not for us as prosecution advocates the luxury of any form of presumptive disclosure. For us, we must not abrogate our responsibility under CPIA by disclosing anything that doesn't pass the test. So it says 135. So to wrap up, finally, thoughts on a postcard, just some thoughts. Obviously, the main thing about these guidelines is they are heavy, they are dense, they are, they're 50, 60% longer than the last lot. And there is an awful lot of obligation and onus placed on the prosecutor to do their job more effectively. In other words, to try to deal with the problems that have gone on in the past and make sure those are sorted out and don't happen again. But that too creates opportunity for the defense advocate, because all that rhetoric, all those obligations make life really quite quite difficult for the prosecution advocate. So here are some ideas about how to take advantage of the AG's guidelines. It's not just a prosecutor document, it's something that you as a defense advocate can deploy in your arguments. Pre-charge, PCE, let's get with the program, early engagement, etc., etc. Tell them if you've got a good defense, or if you've got a really perfect defense, you're right about something, tell the police in that formal way, and hope they will then be obliged to go and check it out. Schedules, always a weakness for prosecutions. Complain, make them go to task. Paul Sharkey will hate me for mentioning this one, but I think he and a large group of COLP spent about a month trying to sort out the descriptions on one schedule after we complained at court about not his fault, the lack of quality of one particular schedule that in a large case he and I did together. Presumptive disclosure, treat it, approach it on the basis that you should be just having it and you shouldn't really be arguing about it. Frankly, that's probably how a judge is going to look at it. But Mr. Seymour, it says here, presumptive disclosure, but you're saying, are you sure you've looked at it all? Come on, just hand it. You can see how it's going to pan out in court. So insist on getting all of that material without fighting really about it. DMD, again, explore it, exploit it, make the prosecution, take the prosecution to task about the way in which they express their lines of inquiry, make them go further if they should be. And don't let them sit back if they take the view that the complainant's phone isn't required, and or have good basis for thinking that there's material that can be shown. Articulate that, tell them why, and make them move forward. And if they won't, make the judge make them move forward in those ways. Review all your material. I think there may even be GFS fees for certain types of unused material review. You may not be paid brilliantly for it, and you may not be guaranteed to be paid until the end, but you can, if you deal with it correctly, get yourself paid for it. And know the law and know these AG's guidelines, because it sounds a bit twee, but they are your friend here, because there's so much useful material to deploy. And if the prosecutor does everything the AG's guidelines says they should be, they'll be stuck on your case dealing with the disclosure forever and a day. And they won't be looking at the evidence, hopefully. But equally, prosecution advocates, how are you going to deploy these to your advantage? Pre-charge. Well, to some extent, it's really a question of being forewarned, I think is actually a key message to take out of this. Insist on revelation of all the potentially disclosable material so that you've got the full scope of that which assists and undermines known to you from the outset. And why is that? Well, turn what might appear to be a problem in the first place into an advantage. Deploy your arguments. Think about other lines of inquiry that you can put that potential difficulty into context, which may be perfectly capable of logical explanation and may not be a weakness at all, and if it's properly explored, rather than hitting you late in the day when it's too late to do anything about it. Have your proper schedules dealt with correctly, because then you can insist on looking at the unused material. My experience of prosecuting is that the unused material is frequently a gold mine, because the reality is that, as well as missing the odd corker and nugget here and there in the way of undermining material, often an investigator will have missed a large number of bodies of material that are going to assist in the evidential picture, and you can then ask for those to be converted and put into evidence. Insist on a full revelation of the presumptively disclosable, and save yourself the work of being asked to individually yourself review it, and insist on a full and accurate DMD so that you can be engaged in the strategy of the reasonable lines of inquiry that will go to make your case evidentially more secure when you're at court, and make your task of prosecuting that much easier. And I haven't put it down there, but take advantage of the fact that the code says, and you can point to it, or the guideline says, that you should be having lots of case conferences to discuss all this disclosure, for which you will then be, dare I say it, handsomely remunerated. So there's lots to talk about, there's lots to look at, but that's a quick canter through it all. If you want the handout, you're welcome to it. Hopefully I'll read it again at some point to another audience, instead of at that point, hopefully all the flaws in it will have been identified, and all the spelling mistakes and all the rest of it can be resolved, so it looks a slightly more professional professional document. But thank you very much for listening, and I don't know if anybody's got any